There's an ancient Chinese general named Sun Tzu who authored a book called The Art of War. It's pretty famous. There's a couple of lines from it which I think are pretty important and applicable to this case. First one is, the supreme art of war is to subdue the enemy without fighting. The second one is, the wise warrior avoids the battle. Now, these are obviously very serious charges. And the state is not promoting a theory that Carl Wimpey is a bad man. I don't know Carl Wimpey. The only view I have of him is what occurred on video. I'm pretty confident I have a good idea of who Arthur Richter is. You can see that plain as day on video. I think when I refer to him as an asshole, that's probably being polite. But the bottom line is, despite Mr. Richter's actions, Mr. Wimpey is still culpable for his actions. And that's why we're here. Now, we're going to go through the indictment, the elements, and we're going to talk about what the charges are. Alright, because people may have some conceptions about what constitutes murder. When you think of murder, you think of somebody getting shot in the street, somebody getting stabbed, somebody getting strangled. You don't necessarily think of a bar fight. Okay? But this is specific statutory language that fits this case and for which Mr. Wimpey's been indicted. So let's go through it. We're going to start with count 2, felonious assault. Carl Wayne Wimpey Jr. on or about the 31st day of January 2018 in Lucas County, Ohio, did knowingly cause serious physical harm to another. Okay? Now, we got definitions that you're going to receive in your jury instructions tomorrow regarding serious physical harm. There's some that I've highlighted that are a little applicable to this case. The first one, any physical harm that carries a substantial risk of death. Well, anytime you put your hands on somebody in a violent manner, there's a risk of death could occur. Doesn't matter where, doesn't matter when, but that risk is definitely present, especially when you're throwing punches. Any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. What are we talking about? We're talking about Mr. Vasquez being unconscious. He gets knocked unconscious after the final punch by Mr. Wimpey and he never wakes up. Glasgow coma scale of 3. The lowest number you can get on that scale is 3. He's in the hospital for 4 days, he never wakes up. That's a temporary substantial incapacity. Then you have any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. Again, each of the blows that are inflicted that are of significant force on Mr. Vasquez are on the right side of his face, and what the medical records show is that he has a fracture of the maxilla, which is the upper jaw. We're not talking about the mandible, we're talking about an upper facial fracture. Okay? These are all serious physical harm. So, did the state prove felonious assault? Defendant punches Daniel Vasquez approximately 6 times. Physical harm equals substantial risk of death. Daniel Vasquez suffers a fractured maxilla, facial fracture, temporary serious disfigurement. That's serious physical harm. That equals felonious assault. Daniel Vasquez knocked unconscious, substantial incapacity. Again, serious physical harm, felonious assault. Daniel Vasquez hospitalized for several days, surgical intervention. He has a craniectomy. He has a bone flap removed from his head. He's unconscious, he's in a coma, substantial incapacity, serious physical harm, felonious assault. Absolutely the state's proving felonious assault beyond reasonable doubt. You saw the video. I don't need you to show you the clips again. That expert wants you to believe that Mr. Vasquez being thrown to the ground was the most violent thing that happened to him. I paid a decent amount of money to say that. But anybody that's being reasonable watching that video Can you really look at those punches that are thrown by a guy who's 6'5", 290 pounds, and a 60-year-old man, and say him being tossed to the ground was more violent than the two left hooks that laid him on the ground? The state submits to you no. Now let's look at murder, count 1. And the reason why we address count 2, felonious assault before the murder, will become apparent once we talk about this. Carl William Wimpey Jr., on or about the 31st day of January 2018, in Lucas County, Ohio, did cause the death of another as a proximate result of committing or attempting to commit an offense of violence. That offense of violence needs to be a felony of the first or second degree that is not voluntary manslaughter or involuntary manslaughter. Well, we refer to that as is a predicate offense. And this is what I was talking about in the opening statement. The state does not need to prove motive. The defendant was asked by his attorney, did you wake up intending to murder anybody that day? Doesn't matter the way the state's charged. Doesn't matter what his intentions were. All that matters is whether he knowingly caused serious physical harm to another, and that serious physical harm caused the death. Felonious assault. So if the state proved felonious assault, that means that the state proved murder. So let's look at the elements. The defendant punched Mr. Vasquez 6 times. Again, that's physical harm, substantial risk of death. Daniel Vasquez suffers a fractured maxilla, temporary serious disfigurement, serious physical harm, felonious assault. Daniel Vasquez knocked unconscious, substantial incapacity, serious physical harm. Remember, he never wakes up. That moment that he goes down next to that pool table, just before Mr. Wimpey's fist hits his face, is the last time that he's conscious. Substantial incapacity. He's then hospitalized for several days. He's treated, he's seizures, he has a stroke. They try to save his life with a craniectomy. It's unsuccessful. Substantial incapacity. Mr. Vasquez dies at the hospital as a result of complications due to blunt force trauma to his head. This is where felonious assault transfers into murder. It becomes a predicate offense. Mr. Wimpey put Mr. Vasquez in the hospital. Mr. Vasquez doesn't leave the hospital. That means that Mr. Wimpey is responsible for his murder. You're also going to receive a jury instruction on what's referred to as natural and foreseeable consequences. There are some highlighted portions that are important. The defendant is also responsible for the natural and foreseeable consequences or results that follow from the act. If the defendant's act was one cause, the existence of other causes is not a defense. So what are those other causes? Defense counsel is going to stand up and he points out, and he did through his expert, that Khalil Assad just violently threw him to the floor. He took Mr. Vasquez and he just threw him. You know, and when he gets to the floor, his head bounces off, and that's more violent than a punch. Even though the expert couldn't differentiate between a jab and a left hook, he knows that this is more violent than a punch. The problem with that argument is the defendant knowingly struck Mr. Vasquez. And it's on video. And his act was one of the causes. So it doesn't matter what Khalil Assad did. What matters is what Carl Wimpey did. You also are going to have an instruction on what's referred to as consciousness of guilt. There's testimony on video that the defendant left the scene. Leaving the scene may tend to indicate defendant's consciousness or awareness of guilt. If you find the facts support that the defendant engaged in such conduct was motivated by a consciousness or awareness of guilt, you may consider that evidence in deciding whether the defendant is guilty of the crimes charged. Well, who do we have as the participants in the real fight? We have Arthur Richter, who starts the fight. And again, he's an idiot. He's got his right arm in a sling, he recently had surgery, he's half the defendant's size, and he's trying to pick a fight with him. And while each and every one of us has a constitutional right to be stupid, sometimes stupidity can have negative consequences. Sometimes there could be collateral damage that results from someone's stupidity. And in this particular circumstance, Mr. Richter got his uncle, Mr. Vasquez, killed because Mr. Richter messed with the wrong guy. Mr. Richter picked up a fight with a guy that was willing to stop to him. And quite frankly, if you watch that video, Mr. Wimpey tosses him around the bar without a problem. And he does the same with Mr. Vasquez. But there's only one person out of that fray that leaves. That's Mr. Wimpey. Mr. Richter stays behind even though 911's been called. Bartender doesn't want him in the bar either. She wants everybody out that's causing a problem. But who are the only people that leave? Mr. Wimpey and Mr. Mossad. Now Mr. Wimpey wants to believe that he's incapable of doing anything on his own because he didn't, Mr. Mossad was the driver, he had to go with him. It's a 37-year-old man. He found himself in a circumstance. He's fully capable of making a decision on how to handle it on his own. He just doesn't have to wait or react for Mr. Mossad. Bottom line is he knew 911 was being called. He knew that he was just involved in a fight. And whether or not he knew the level of harm that he caused, he knew that he was involved in breaking the law. Because you can't just get into a fight in a public place with other individuals. It's not legal. And he knew the police were on their way. So he left. Did he go far? No, he went to another bar. But the police don't know that. Because if you heard the 911 call, the bartender said, I don't know which direction they went. Again, this is not a circumstance where we're putting forth that Mr. Wimpey is a man of bad character. I'm not saying he's a bad guy. I think there's at least one person on this jury that during voir dire talked about being in a bar fight himself, and that doesn't necessarily make him a bad guy. And Mr. Wimpey's not on trial for being a good guy or a bad guy. He's on trial to determine whether he committed murder. And just because he didn't intend to do it, doesn't matter. The bottom line is, he engaged in a fight that he could have walked away from. And he chose not to, he chose to engage. And by choosing to engage, a 59-year-old man lost his life. And over what? Because some knucklehead with a neck tattoo says there's a bunch of dumbass motherfuckers in here? Really? The bottom line is the state's proven its case beyond a reasonable doubt. And we're asking you to find the defendant guilty of both counts. Thank you.